maybe for the first 10 minutes or so, we can just recap on what we did so far. And in doing that, then we'll be just reminding ourselves. Thereafter, I will want us to study one case law. And in studying that case law, then I will be dealing with two things. I will be dealing with one of the important cases for the purposes of your examination and for the purposes of your understanding of how to draft legal opinion, how to draft your answers, or how to answer your questions, as well as to how to cite cases. So I'll be dealing with three things at the same time. Now, just a quick one, because we have the revision is precisely for chapter 1 and chapter 8. My name is still Tupane Peshley, and my father's name is still Hwale. And the revision is precisely number one, to remind ourselves to say that what we're dealing with here, we're dealing with the fundamental document which came as a result of our painful past, and this document then give effect to our new democratic dispensation, and is a document which gives the state the authority to act as we speak. It's a document which gives the authority to behave in a certain manner. So it establishes certain organs of state and structures, and it authorizes and regulates and limits their powers, including establish other institutions and persons, and provides grounds for the rules of effecting as a constitutional state. Now, throughout our discussion for the past two or 3 weeks, we have been focusing on the principles governing the separation of powers. And we've been saying that is the relationship between three organs of state. As I always say, is a res politica in Latin, res politica, because sometimes one will say, please define res politica in as Latin as it is now. Just because it's called in Latin, then you think you don't know the answer, as you know the answer very well. So principle of res politica is penned down by Charles Mosteku. It simply means that there should be checks and balances amongst the organs of state. Then what it does, then it says there should be legislature, executive, and the judiciary. So three arms of the state or the organs of state is two things. Then other than that, the constitution itself then regulates the relationship between three spheres of government, being the national, provincial, and local sphere. Now, this six bodies, if I can use that word, then they are what we are going to deal with throughout this dealt with the importance of separation of powers at length. I'm not going to repeat. Now, importantly, at the back of your mind, you must always know this. Say that legislature, section 43. What does legislature do? What does the executive do? What does the judiciary do? In short. Now, can I hear from anyone quickly and make reference to those sections quickly? What does these three bodies do? Make reference to legislature, executive, and judiciary. Anyone who can say the case should form the hip and say those then refer to case law. It's not case law, sections only.
Okay, I think from your question, you were asking whether we would be able to articulate the three organs of the state, which is the executive, the legislature, and their judiciary, and also quoting directly from the Constitution in terms of the relevant section.
Yes.
But however, what I'm able to do is probably to articulate their specific functions, like, for example, the judiciary. They derive their source of power directly from the Constitution. However, their role is to carry out what they call judicial review as part of the checks and balances in terms of the constitution. And the legislator, their role is to amend, enact, or repeal legislation. Then the executive, it's mainly implementation of policies through the various ministers and provincial MECs.
Yes, then your colleagues should assist you in terms of the three sections. Third section, which established the judicial, one section which established the legislature, one which established the executive. Let it not be answered by you, but one of your colleague. So these are the sections for everyone to look at.
Yes, legislature is section 43, executive section 85, and judiciary section 165.
Absolutely. Consequence of that, then we have three spheres of government, which are the national executive, again 75. Then we have a provincial executive, which is section 104 and 125, led by the premier. National executive led by the president. Local government led by the mayor. In terms of section 156 of the constitution. So the premier, so national we have ESCO members, we have the premier. Provincial we have ESCO members, we have the premier. Then so national we have ESCO, we have premier, we have parliament. Similar provincial we have premier, we have ESCO, then we have provincial legislature. Local government we have a mayor, then we have a council of that mayoral council. Now, those are the spheres of government, and those are the things which we dealt with yesterday when we dealt with multi-sphere government. Now, you have repeat what I dealt with regarding what does this thing do? Who elect the speaker? What is the primary role of the speaker? What is the role of parliament? And this is to say to you that please study these things. They are very much important for the purpose of the examination, and you must further know the numbers required to elect the speaker, the numbers required to constitute number one, the numbers required to constitute the parliament, the numbers required to elect the speaker, the numbers required for to constitute parliament, and the numbers required to pass any law or legislation, and the numbers required to amend the constitution. Okay. As I was saying, please understand the numbers required by a parliament to do certain things. For example, to amend the constitution, to pass any ordinary legislation, to elect the speaker, for impeachment, vis-a-vis for motion, for normal motion of no confidence. Now, and that is in relation to that. Now, I will not deal with these things at all. What I want to deal with is case law. And in doing that, I will try to go to your, what is the thing? Your tutorial letter. I like it the way it is drafted. And all go to a tutorial letter 102 for 2024. You know, we all open this book, this document. You know, open this document. Do you have it with you? Can I see by thumbs up? Can I see by the thumbs up? Can I see by the thumbs up? Can I see by the thumbs up? Perfect. Majority rules. Now, this deals with your chapter, the summaries from page 12 to 87. I'm not interested in those summaries. What I'm interested in is the law or is the judicial activism. I will request that we go to page 111. All I've been talking about EFF1 and EFF2, and I dealt with it. I think when we're dealing and when we're dealing with independence of parliament, section 42.3, if I can recall very well. So, but for the interest of just refreshing your memory, EFF1, ordinarily I was going to request one of you to summarize it quickly, but in the interest of time, I will just shoot now. You recall in 20, what was EFF found? Somewhere 2013. 2013, we had a new party, a nearly costed a nuisance party, but it's no longer a nuisance now. It is a fully fledged political party. We had a EFF formed. The EFF came with the DA1 when they chatted for bring back the money, and all sorts of things. Now DA launched an application, they went to court, then they declared, then the court protected it. But now that is irrelevant for the purpose of our discussion. What is relevant now is that the judgment of the Constitutional Court is the applicant. Who is the applicant? Is the EFF against Mank, against the Speaker of Parliament, second respondent, former President Jacob Zuma. The third respondent is the public protector. Then DA also launched his own application in order to join as friends of the court, what you call amicus. I think there was another one where amicus being corruption watch, but actually it's not bring as an amicus, but it was a separate application which was then later merged into one. But there was one amicus now. The judgment is drafted by who? It's drafted by supported. Unanimous means that he is supported by all these people concurring. But in the simple English, that is supported by all these 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. All these 11, which cannot be 10, cannot be 11, must be 10. Yes, supported by 10 because all in all must be 11. So it cannot be 11. So it's going to be what? How many going to be? S must always spectrum must be between 8 and 11. So now this judgment, in summary, maybe the summary will come out of the beautiful writing of former Chief Justice Murembe. What does it say? It says in the introduction, one of the crucial elements of a constitutional vision is to make decisive break from unchecked abuse of state and the resources that was visually institutionalized during the apartheid era. To achieve this goal, we adopted accountability, the rule of law, the supremacy of the constitution as values of our constitutional democracy. Very important. For these reasons, now you see footnote 59. So it means that he's quoting something. What does he quote? He's quoting section 11C of the Constitution. Now, there's a section which talks about that to achieve this goal, we adopted the rule of law, supremacy of our Constitution. So section 1, section 1, subsection 1C and D, is the foundational section which deals with the rule of law and establishes the supremacy of the Constitution. So when you are writing in a form of opinion and advising, to avoid plagiarism, you must consistently, when you're quoting something from somewhere, make reference to it. Failure to refer to it, then it will be come out to plagiarism. If you are coding as it is, then you must put them in inverted commas as italics. Now, let's see an example of a judgment which is quoted in full. Normally, this is not a good example of coding a judgment, but it's a good example of coding a judgment. Moran sometimes writes was short, but no. I don't want to go to Zondo. Zondo writes well, but he has an appetite of writing long judgment. That's why this judgment is very short. Yeah, Morain's code judgment of MEC of Eastern Cape, and another basis Kirkland investment. How does he code it? Said this was amply resumed by Cameron J in Kirkland as follows. Then he coded there, then make reference to it, coded as it is. There's the paragraph which deals with this thing. So this is how you code the cash flow in full. Then what do you do? With them as it is, the way it was written, instead of putting italic, then you just code it is the way it was written, that then put what foot in full and paragraph way, or the paragraph as it is, paragraph 89. So when you code the case law, you must code it the way it is, then put the case there, put the citation there in full in the footnote. But some people will put case law, the full citation here is also fine, but for the interest of space and time, then but when you are writing an examination in a closed book, one does not expect you to code the rest of by volume 2014 volume 5 BCLRC CC. No. One does not expect you to know all those by heart, but one does what one now want you to know is the full citation of the case law and what it talks about and summary. So understand what I'm talking about. Let's go to Zondo. He writes well, would show us. I don't want to go to my P-notes. Any question on citations? Any question on citations? Yeah, we'll deal with it later. Now let's continue with the judgment, because this judgment is important, because we must know all those things. So I'm just trying to assist you in reading a judgment. So the judgment in summary, with the complaint which was lodged by members of parliament, by members of parliament and several civil servants or civil societies regarding the security upgrade which was made at Nkandla, the presidential private residence for the former president. Now, which the report came out to say that they were extensive. They were certain security measures which were outside the scope of the mandate. Now, there is the report that number one, that the president acted in breach of his constitutional obligation in terms of section 96(1), 2B and C of the Constitution, which provides that the conduct of members of parliament or cabinet ministers should be in the following: should not expose the office and other people to risk of conflict with official responsibility and private interest. Use or any information in transit time to enrich themselves or improperly benefit from any of these things. Now, as a result of all these things in summary, then it was a situation whereby the public portal's report is there, then there's a question of whether or not it's binding or not. The long and the short of it is that this court then found that the report, okay, blame it before go there. Then the judgment, when you read the judgment nicely soon, then it talks about the purpose of the Office of the Public Protector. Then you're going to see what is the purpose there, nicely drafted. Importantly, it does say, is this one of the most invaluable constitutional gifts to our nation in fight against corruption, unlawful enrichment, prejudice, and impropriety in the state affairs for the betterment of good governance. That's the beautiful words of Moen there. Then it deals with the then additional powers, which deals with an ethics, which were not the original powers from the Constitution. Now he deals with the legal effect of the remedial elections, whether they are binding or not. Then later on, he deals with whether or not can they be ignored or not. Then he says this very much accords with the High Court decision in DA versus the Speaker to the effect that for the reason now he quotes the case law. So this is when he quotes the case law. So they must quote the party, another party, and another party as if they are. So ordinarily you quote the full Democratic Alliance in full, let's say South African Broadcasting Corporation, where says the following. So this is abbreviations. So I guess you quoted them previously. Now, when you then after this thing, then it talks about other things. But now we must go to the order. What does he order at the end of the day? Okay, number one, and it deals with the remedy to say that the thing must go back to Parliament to ensure that this remedial action are given effect to. Now, then what is the order? Then the failure by the president to comply with the remedial actions against what is inconsistent to Section 83B of the Constitution, read with what, and therefore is clearly invalid. This is the order. So at the end of all explanation of why you are arriving in summary, this is what must do. But what is important is that now this thing is back to National Assembly. Where is it? Yes, paragraph 1, paragraph 3. This thing is binding, is inconsistent. What does it do? Parliament must ensure that the president is held liable for outstanding amount and the demand of the all sorts of things. Now, this is what it is. Now, this in short is how judgment looks like. Any questions? Any questions? This is what we call EFF1 judgment. It's a long judgment, but we try to summarize it. It's a long judgment, but you must know it. EFF1. So the long and short of it is that this is an EFF is a judgment which deals with whether or not the remedial action of the public protector are binding or not. Now, following this one, then we had the EFF2 judgment. EFF2 judgment, in short, is the one which dealt with the secret ballot, if you can recall. No say, Munyai was a belly.
No, sir. I was replying to you when you said you were asking that. Is there any questions regarding judgment?
Okay. But do you understand the reading of the case law?
Yes, sir.
Perfect. I'm happy. Now, this is the second judgment, which deals with which I call EFF2. This one deals with the secret ballot. The long and the short of it is that then, as a result of the report of the police protector, then they went to parliament and said that the president breached the constitution, what. They posed the motion of no confidence, and the impeachment process was about to start. But that is the time where people were saying that EFF, ANC MPs must vote with their conscience, because they must vote with their conscience. If it's going to be open voting by hands, people will not be able to apply their mind properly. They will be afraid that others will see them and what. Then what did they do? They brought the application to application, application to the court, and after went to the constitutional court. Then what did the court say? Say that in this matter once again. Now this is Zondo now. The quorum is Mongoy, Matlanga, and Zondi. Then there's another quorum there. So this one is an interesting one. So this one is an interesting one. So there's a judgment of Mongoy, Zondo, what. There's a majority judgment drafted by Judge Jafta Jane. There's a dissenting judgment drafted by Zondo from page 1 to 128. Then we have the one of Jafta. The Jafta one is very much short. He writes very short judgments. I like his writing style. Now, what does this matter cause deals with? So to summarize it nicely here, that this matter, once again, so when the court is called upon to pronounce upon complaints by political parties represented in the National Assembly, and the National Assembly failed to fulfill its constitutional obligation, in this case, parliamentary mechanism to hold the president accountable, and the constitutional obligation imposed to National Assembly to hold him accountable. It is not about holding any president accountable as such, but about National Assembly holding its president accountable. President Zuma, as a result of President Zuma accountable for his failure to implement public protector remedial action. As we all know, the report is a report of 2014. Now, there was another application brought by UDM to join this thing, like it did with the previous one. Now, this resulted in what we call secret ballot. As a result of this, at the end, then the court said Parliament should go back, and it's not a long judgment, it is because it is dissenting in the majority judgment. And it deals with the exclusive jurisdiction in the EFF1, what. But at the end, then the court said the secret ballot can be there, and then Parliament was directed to amend laws to give effect to secret ballots. So this is the judgment. So the order, in short, say that paragraph 22, this quarter exclusive jurisdiction is fine. The failure by National Assembly to make rules including the removal of the president in the section 9 violates the constitution and is invalid. National Assembly must comply with this thing and make rules referred in the above without any delay. And we all know after this thing, then it was the end of the road. The president then resigned without the parliament giving effect to those rules. Now this is EFF2. Now, do you understand? So out of those cases, we dealt with too quickly. Cases which you'll find here, we dealt with this too quickly. What you are left with, this one of UDM, which is sorry. We are left with UDM 1. one which also arises from this one, because it's the same thing. Then we have a Democratic Alliance versus the Minister of International Relations. There's an interesting one as well. You will concern the Rome Statute, when after we had the problems with Omar al-Bashir, then the president then decided to, okay, we're going to withdraw from this thing so that we're not faced with this thing. And likely it was before the issue of Russian president coming into the party. Now, this is what is left now. I'm left with issue of corruption, which not that much important for now. I'm not going to deal with it. But do you see the judgments and how we quickly summarize them and deal with them?
Yes, sir. And thank you so much for providing clarity. Good evening. Can I ask a question?
Liberty.
I would like to know, as we deal with the legal opinion in the exam, are we supposed to quote all this case law, or we can just pick one or two? Yeah, that's my question. Thank you.
So I didn't hear it properly. Can you repeat?
Okay, I'm asking if when we deal with the legal opinion or a question in the exam, are we supposed to refer to or quote all this case law, or we can just pick one or two of them? Actually, I would like to know how many are we supposed to quote? What is an acceptable number of case law to quote in the exam? Thank you.
Yeah, so you must prepare as if you're going to court in this state. Let me put it that way. You must prepare as if you're going to court. You must ask yourself, when I'm dealing with the powers of the public protector, how I'm going to deal with that question. For example, now what I was dealing with the with the cases, but at the same time I was dealing with how to read case law and refer to them. Now, if the question comes regarding the public protector, for whatever scenario may come and say the public protector have issued the report, and what the minister, the MEC, whatever, does not want to comply with the report. The question is, how do you answer that question? Given how we learned on how to answer question yesterday, and the lecture which we just had now regarding how we're going to answer that question.
Oh, okay. Is it a question?
Yes, okay. I want to see how you're going to answer so that I can say whether or not you are fine or not.
Okay, so in terms of answering the question about the public protector, firstly, I would state the functions of the public protector, the section in that regard, and the public protector being the...
So you must always have an introduction.
Oh, okay.
Yes. So although it wastes time, but it's important that then you understand what you are dealing with. So your introduction sometimes is about what is the question which you have to answer here.
Okay.
Yes. So if the question is about whether or not it's a long story about the public protector issued the report, what the MEC is failing to implement this thing, and is saying that they've got nothing to do, they are not enforceable now. then your summary will, the first question will say that it is a tried law that the remedial actions of the public protector are binding. Understand?
Okay.
So that is the summary of the scenario which we are dealing with. Now, in giving effect to that, section so and so says so, so and so says so, says so and so says so. This matter came before our courts previously. How did it came before our court before EFF1? And this is how the court have pronounced on it, and this is what they said, and the subsequent judgment which came thereafter.
Okay.
Yes. So, like as I said yesterday, you ask yourself, what is the nature of the dispute before you? When every time you want to advise your client, you must ask yourself, what is the legal action, legal question of which my client is asking me here? Once you master that, then you are gone. If you don't understand the nature of the dispute, then you can't answer the question.
I got that. Thank you.
Maybe let's do the Rome statute quickly, then so that we are out of this judgment. Then the rest will be in your court. As I said earlier on, that the next judgment is the one of the yes, quick one. This one then dealt with the issue of the bringing challenging the okay. Can you all read the first paragraph of the judgment? Interesting one. By Mujaber DJP.
Do you want us to read it out loud?
Yes, please do that, Lynelle.
Okay. This case turns on the separation of powers between the national executive and parliament in international relations and treaty making. It calls for a proper interpretation of Section 231 of the Constitution of the Republic of South Africa, 1996, the Constitution. The primary question is whether the national executive's power to conclude international treaties also includes the powers or the power to give notice of withdrawal from international treaties without parliamentary approval. Related to that is in ancillary question whether it is constitutionally permissible for the national executive to deliver a notice of withdrawal from an international treaty without first repealing the oh my goodness, I'm reading from what you have posted here. So if a little one more. Okay. Without first repealing the domestic law giving effect to such treaty. At the heart of the dispute is the withdrawal of South Africa from the Rome Statute of the International Criminal Court, the ICC.
Thank you very much.
Okay.
No. Okay, that's it. You'll see that the litigation history stems from the genesis of the refusal by South Africa to arrest the president of Omar Hassan Ahmad al-Bashir, the president of Sudan. He was in South Sudan. I think it's South Sudan. When he visited South Africa in 2015 for the African EU, the AU summit. Now, this is the implication of the separation of powers in particular, to say that now you have a parliamentary body saying that their president cannot withdraw from this treaty without the parliament giving effect to this thing, at the heart of this thing. That they withdrawal is one thing, but they're saying, DA says that bring this matter before us in Parliament for us to debate on it and vote on it. As the Parliament, we have a final approval over this thing because it's us who pass the law, it's us who make the law, and therefore it should be us who withdraw the law. Do you understand the point? Perfect. So this is the heart of it, to talk about the withdrawal from the Roman statute by the minister then. So the rest, the issues regarding the political, who should do what, to me, they are essential or not much relevant for our discussion as law students. What is important for law students to understand the nature of the question asked here. The nature of the question is, we have a situation whereby the executive, they are withdrawing from this law which was passed by Parliament, and then Parliament says no, or a certain political party says no, this should first actually come from us, and us saying that this is how we should do, because law is made by the Parliament for the people. Therefore, Parliament as a body has the political power in terms of Section 43 to repeal laws, not the one way around it. So that is the implication of the entire thing. There are other issues that are just peripheral in terms of the judgment. Now, I will then want us to go to okay. So now before I want to go to see the issues of public participation. So now the court then talks about the public participation in enacting legislation, what. So kind of say that laws are made by the people for the people, not the one way around, not the other way around, whereby someone can just withdraw or impose law on you without you or without the citizens themselves. So I'm speaking to myself. I was saying, do you see the order there on the screen?
We can now see, sir, you were not audible for the past few seconds or few minutes. Yeah.
I spoke about public participation and all sorts of things to say that the laws should be made by the people, for the people, by the people, and not by the executive, not by the courts. But where the people are in Parliament, they are the ones who makes the law for that process. Now, at the end of all those things is a long judgment, but at the end of it is just whether or not can the executive make laws or repeal the laws without Parliament's approval. And the court said the notice of withdrawal from the Rome Statute signed by the first respondent being the Minister of what of International Relations Cooperation on October 2016 without parliamentary approval is unconstitutional and invalid. And for us, our principle, which we have learned earlier on, is that Parliament's primary duty is to make law, amend laws, and repeal laws. And cabinet to decision what should be declared unconstitutional and invalid. Now, this gives effect to our principle of separation of powers. The rest of two councils, the rest of what they have got, they are irrelevant for us about the issues of cost and what. What we are interested in, what is the principle which we are dealing with here? So when you are reading all this case law, you must always ask yourself, what is the principle we are dealing with here? And if the question comes now, talks about another arm of the state doing certain work and asking you for legal advice, you can always refer to case like this. So for example, if you are dealing with the separation of powers, this is one of the cases which deals with the separation of powers. When we are dealing with yesterday we dealt with the case of Limpopo Premier. It also deals with the separation of powers in that certain powers is reserved for certain sphere of government. Now we make reference to that case law. So what is important always is to understand which principle are dealing with, whether can we refer to this case law? How does it refer? We dealt with these two case law. The first case law that with is this one of EFF1. We dealt with case law of EFF2. We dealt with the case law of DA, First Minister of International Relations. Those are the important case laws. Now, just to recap, we dealt with the principle of separation of powers at length previous time, but what I want us to deal with is just to remind us about those figures I talked about earlier on, to say that please be mindful of the figures to elect the speaker, the figures to constitute parliament. Also, then be mindful of the powers of the president and his term of office. Now, the judicial power, we all know about it. To say that they're vested in the judiciary in terms of 165, and we all know these things. We dealt with them at length at time. But what I intend to say, if we can't get clarity on, is to test your understanding on the separation of powers. Let's do a short question. But I will prefer that, because we don't have time, if we can't discuss it amongst yourself about this thing. You read the question for 4 minutes, then you discuss it, because I don't want us to waste a lot of time thinking about writing down, because we don't have time at all. Do you agree with me, or do you want to write it down? Then it's up to you, because I'm thinking if we write it down, it may take time, but I will want us to discuss it at length quickly.
I think it's better we discuss it, sir.
Yes, because of the time constraint we have. Now, here is the question. Let me flag it. This shows how important it is. Can you read the question for yourself for until 1:15? Then we discuss it thereafter.
Okay, I'll go first. So in my opinion, we are explaining the impeachment as it relates to the president, judges, and the public protector. In particular, is there a similarity in terms of the consequences of impeachment? To answer this question, you are required to give a substantiated opinion as to whether the impeached public protector is still entitled to gratuity of 10 million rand on vacation of office. So for me, the similarities, the impeachment, I would explain the impeachment of the president, of the judges, of the public protector. And according to Section 89 of the Constitution, the National Assembly alone may remove the president for any violation of Constitution or the law, serious misconduct, or inability to perform the functions of office. And a 2/3 majority of the parliament is required to remove the president. No other institution in spheres of government can impose the impeachment of the president. On judges, as set out in the Constitution, Section 2771B provides for the National Assembly to call for the removal of the judge by a resolution that is adopted through a vote of at least 2/3 of its members. While Section 177 obliges the president to remove a judge from office upon the National Assembly's adoption of a resolution calling for a judge to be removed. And on the public protector, it is section 194 of the Constitution that makes provision for the removal of the public protector as one of the heads of Chapter 9 institutions. And also it is on the ground of misconduct, incapacity, or incompetence. And the removal process of the public protector, it has got a few steps, which include the filing of notice to the Speaker of National Assembly, and there should be an ad hoc committee, which is an independent panel formed by the very same parliament to deal with the matter. And then they should report back to the assembly, and the impeachment happens also via the votes of 2/3 majority. So in my opinion, the impeachment of the public protector, for me, she or he will not be entitled for the gratuity of 10 million rand on vacation of office, because she or he would have been impeached for his or her incompetency, incapacity, and misconduct. So, okay, in our case in South Africa, we have seen the former public protector, of course, was impeached, and he's in court fighting for her gratuity. But I feel like she does not deserve it, because she did not act in accordance with the rules and everything that is within the law that she was supposed to be protecting. The very same constitution she should be protecting, she contravened the constitution. That is the reason why she was impeached. Therefore, she is not entitled to the gratuity. Thank you.
Yeah, this is how we dealt with it previously. Do you remember? Do you remember this question? What I did not hear you referring to is case law. Anyone with case law? A case law?
Case law would be...
Oh, not you, Mpo.
Okay.
Bakubel, sorry.
Good afternoon, sir.
Yes.
I do not have a... Hello?
Yes, I'm listening.
Yes, I do not have a specific case law, but in my opinion, I think this case law is very significant to cite. The case of economic freedom fighter EFF versus the Speaker of the National Assembly, where
Which one?
the one in, was it 2016?
EFF1 or EFF2?
I think it's one. Let me just check on the notes. Let me just check it. Yeah, I think it's one. I didn't specify I didn't check if it's one or two. But in any case, this case emphasizes on the importance of accountability and the importance of the restrictions that people who are in office should adhere to. It further, let me just check here. It further sort of provides a sort of mechanisms on how people who are in office should function in respect to our constitution. And sometimes you find the likes of our former public protector being impeached. It doesn't give relevance to the issue, the question here, but it's very important to refer when we are going to deal with it in the exam. It provides those accountability mechanisms and certain provisions that when dealing with cases like this in future, people who are in public offices should adhere to. There's another one that I saw, seems to have disappeared. But on the there's another one. Speak of the National Assembly versus Public Protector. It was in 2020, and the Constitutional Court sort of emphasized on the importance of the public protector's role in holding this is in the case of the president, in holding the president accountable. There's limited cases on the issues of the public protector, but there are cases that cover people who are in office.
Okay.
I'll find out more, then I'll give more detail as we go.
Let me tell you what is my interest. My interest is as follows. Is for you to be able to distinguish, to say, what are the numbers? So what are the numbers to impeach the president? What are the numbers to impeach a judge? What are the numbers to impeach a public protector? That's number one, the numbers game. The second point, what are the sections giving effect to presidents, judges, and public protector? And it was dealt with by the previous speaker nicely. So that part I'm very much satisfied. Now, the question of case law, just to assist you quickly, EFF1 deals with Nkandla. It's just talking about whether or not the public protector's report is binding or not. It got less to do with the impeachment process. What is important, or what deals with impeachment, is EFF2, whereby the Speaker of National Assembly was ordered to say, make rules to give effect to or to guide us when we're dealing with impeachment. So every time we deal with impeachment, we must go to impeachment. We must go to EFF2 and code it nicely. So are we clear there? Now, over and above that, then you then quote any other relevant case law which concerns impeachment. So then the last part of the question then deals with whether or not one is entitled to the benefits accrued to him or her.
Isaac, may I come in? I just wanted to ask, when you say EFF2, which case is it? Is it the same one that is versus the speaker? Is it the one in 2017?
We have a UDM case as well.
The other one in 2017.
We have a UDM case, remember. Can you still hear me, guys? Can you still hear me, colleagues? Can I see by thumbs up? It's a penny here. Oh yeah, okay, no, sure. Okay, it's fine. Yeah, so in the absence, okay, the last point I was saying, I did not hear you dealing with the benefits, consequence, whether or not are you entitled to that. And we, in the previous class, last before this one, I think last week, it was, I gave answers to that. Can someone quickly deal with the issues of the benefits which are forfeited as a result of that quickly? Someone who can do that, then we go to another question. The benefits part, no one dealt with the benefits part. And actually that's the number of that's the second leg of the question. Colleagues, please, let's deal with this so that we can
Good.
Chatrak.
Okay. The only
Please
benefit.
rescue us.
Yes. Okay. The only benefit that I can think of is the pension. Remember, the president and the judges, when they leave office, they are paid their pension and their salaries for life. So should they be impeached, they will lose out on the pension and on the salary as well.
Then the public protector, the question here is about the public protector. Whether or not is he entitled to 10 million? In case law, there's a pending matter, there's a judgment on it.
If my memory serves me well, there is no yet judgment on Mukwebani's case. Okay, our former public protector went to court to actually want to have his gratuity because it was forfeited according to the government. So she will not get it. And now the case is in the court of law. So we are yet to hear if she's still gonna get it or she's gonna forfeit it. But then according to the law, she forfeits it and she has forfeited it already. But then she is actually going against the decision and wants to have his gratuity in full. She wants his 10 million rent. Thank you.
Thank you, and you are correct. There's no judgment. The judgment which we had was in relation to the preliminary points in terms of Rule 56, the access to records, and Part A thereof, which was then dismissed. No, thanks very much. Just you assisted me there. Just forget about it. Luckily, the Klope did not challenge it. His impeachment. So we don't have a judgment also. But what we have is that there's an application. I think it's going to constitutional court now on the issues of the outcome of the leave to appeal for Judge Klope in relation to setting aside the report of the JSC Commission. I think in the mail there is an issue about the composition of the JSC committee, but this is irrelevant for our discussion. This is the second question. Can someone read it?
I'll read. What is the powers of the local government? Do you think local government should be afforded more powers as the primary sphere of government?
You want to apply our mind for 2 minutes, then we discuss it. Then read, consider relevant or annually for annually. Refer to relevant section. We dealt with the section yesterday when we're dealing with multi-sphere. And this question is linked to what we've discussed yesterday. Can you give you 2 minutes? Then we give you 5 minutes. By 22, we reconvene to discuss the question. And hopefully you will also have a look at your notes for yesterday. Then we answer it fully. So thank you. At 22, we reconvene to answer the question.
Okay, can I try first?
Yes, please start.
Okay, what is the powers of the local government? So my answer will be the local government in South Africa is primarily okay, let me say, okay, the local government in South Africa has the objective to provide democratic and accountable government for local communities, and the legislative authority is vested in its municipal council, elected by the community. Their job is to enact bylaws and to see that there is provision of services to the communities. Section 151 of the Constitution gives the status of municipalities, which consist of different categories in our country, which is we've got local municipalities, we've got district municipalities, we've got metros in our country, and section 155 of the Constitution gives the categories in that respect of the different local municipalities. And in my opinion, I don't think municipalities should be given more powers for kind of, what is the question? More powers? Yes, it should not be given more powers because there is the principle of separation of powers, and the relationship between the municipalities and other spheres of government should actually allow the municipality to discharge its powers accordingly and without any interference or encroaching in other spheres of government. Yeah, thank you. I think I've given it a try.
Thank you. Your answer is interesting because you say it should not be given more powers, yeah, which is an interesting one. Anyone who has a contradictory view or dissenting view?
Yes.
Shadrach.
Okay. With respect to my learned friend, I would love to differ in terms of the allocation of powers to the local government. I believe that the local government should be afforded more powers in the sense that they are closer to the people. They are responsible for the day-to-day.
So Shadrach, do you?
Yeah.
Before we can even go there, do you agree with was it Nelly, ne? With Nelly?
Yeah,
that the powers of the local government, they are found in 155 and 161, 156.
On section 156, it's okay. But she also mentioned section 151, which is 151 or 155, which I also need to check. But in terms of 150,
mention reference 155, but she's on the line to object if you have. Yeah, then over and above 155 and 156, where does this powers rest?
I believe there should be in 156.
Okay. No, I'll continue. I don't want to put you on the spot. Continue, put your point. I'll respond thereafter. Okay.
So my minority response is on the issue of allocation of powers. Like what I said, I believe that the local government should be given more powers because they are closer to the people. The person closer to the people, they know the specific needs of the people, and they can easily and quickly address those needs if allocated more powers. Thank you.
What are you saying? Bylaws, for instance, can pass. Can you put your answer on the for the record? I see you have an interesting one specifically for what the bio. So we have an answer of Mpo on the line, who says that the municipality passed bylaws. The Constitution section 60 provides the above mentioned powers. Then he refers to He then says that, in his opinion, this power should be extended to give effect to economic opportunities and the mandate contained in the Constitution. Now, we should importantly bear reference to what is the functions, or where does the economic opportunities and the other powers lies, which is the concurrent powers with other bodies. So what I don't see is the answers is you referring to the powers, for example, vested in other spheres of government, which should be taken away from them and be given to municipalities. That's number one. Secondly, if those powers should be taken away from them, how many numbers do you need to do that? And case law. I want to take that point quickly to close the question, because it's very important for purpose of the examination. And I mean it. It seems like no one is willing to do it. Okay, I will also not go there. What I can say in conclusion is to say that please take your time to consider the multi-sphere government. Please take your time to consider these principles governing the local government. Local government is a very interesting sphere of government, which is in charge of the livelihood of our people. That's number one. Secondly, over and above livelihood, it's in charge of the basic needs of citizens of South Africa. In particular, is entrusted with the powers to deal with sanitation and dignity of citizens. So if you go to the Constitution, within the Bill of Rights, Section 10 deals with human dignity, and it's a very important section. And that section, it does not have subsections, but as it is one of the fundamental rights in the Constitution, which cannot be easily limited. So if there are two rights in the Constitution, which is very difficult to limit, is the right to life and the right to human dignity. 10 and 11, they are important rights. So this is a constitutional law class. So I will be doing this injustice to you, all of you, if I fail to take you along the Bill of Rights. So the Bill of Rights is a very interesting book, which is a fundamental right which the Constitution quoted as the cornerstone of our democracy. I'm not sure if you all have your Constitution with you. Do you have a Constitution with you?
Yeah, I do have mine.
Can I see by a thumbs up? Perfect. So, Chapter 2 of the Constitution is a very important chapter, which then gives effect to the. We had this debate, I think, on the first class or second class, where someone was arguing about, I forgot what was the issue, but then I make reference to the Bill of Rights to say that the Bill of Rights is the cornerstone of democracy in South Africa, and entrenches all rights for all our people and our country at large, and affirms the democratic values of human dignity, equality, and freedom. So there are three important democratic values of our Constitution: human dignity and equality and freedom. So the Bill of Rights, if you consider it, it's premised on these rights. So the section 8 will deal with your application, where is it applicable and where is not applicable. And it will tell you that it is only can only be limited in terms of section 36. And section 36 then will tell you what cannot be limited. That is chapter 8. Then the first section of the Bill of Rights is the equality, which is the first principle of our democratic values. Equality. What is thereafter is human dignity. And human dignity and the right to life, they don't have a comma. I always make this joke. They don't have a comma, they only have a full stop. Section 10 will just say everyone has the right to human dignity, which must be respected and protected, full stop. Section 11 will just tell you that everyone has the right to life, full stop. Then what follows now is unfettered rights of freedom, 6 rights of freedom. We'll talk about freedom of security of person, slavery, or freedom of religion, opinion. You have political rights, you have freedom of expression, you have freedom to picket, and your political rights, you have citizenship, you have freedom to movement and residence, you have freedom to trade and occupation, up until section 22, which is the last right of freedom of trade and occupation and profession. Then what comes thereafter is your socio-economic rights, which are entrenched in your Bill of Rights. What is your first socio-economic rights? Is your obviously your right to trade, occupation, and profession. Then followed by your right to have a free, so your right to have a fair labor practices, or your right not to be unfairly dismissed, your freedom rights, and your property rights. Then you have your housing, you have your healthcare, social right. Then we have all your education as one of the last one. Then the rest is the issues of languages and there. Then that's the end of those ones of access to courts and stuff, and then the rest of criminal law that you will deal with in criminal law. But that's the nub of your Bill of Rights, and that on its own is the fundamental rights of which we find ourselves in. But I made reference to say that amongst all these rights, we have 2 fundamental rights. So if you go to a Bill of Rights and you go to, I think, section 5, section 5, it will tell you in the table, somewhere in the table, it will tell you that their right to human dignity and the right to life cannot be limited at all, because it's protected. It is protected in its entirety. So those are the 2 fundamental rights which cannot be hampered with. So then that's the right. Then talks about invisibility. That's the end of the Bill of Rights. Then what follows thereafter then is a multi-sphere government. Then what follows thereafter? Then you talk about the separation of powers: Parliament, executive, the judiciary. Then followed by the Chapter 9 institutions, and that's it. So I'm not sure if I managed to summarize your constitution to the best of my ability.